I will represent Gladys Jeruto of Tagi against Gladys Toroitich Moi. You have taken over the conduct of this matter for Mr. May after judgment. The judgment is for the defendants. Yes. For the plaintiff applicant and now the criminal. Yes. Collins Toroitich Moi is the respondent who was represented. Yes. There appears to be no representation, neither of him nor that of his counsel. Your Honor, we are before you on account of an application dated 24th of January 2024, in which we are seeking 24th January 2024. And Your Honor, this is a matter seeking contempt orders to be issued against Collins Toroitich Moi and a notice to show cause as to why in the alternate he should not be committed to civil jail. Your Honor, having come on record just about 2 days ago, filed an appointment on 1st of March. That's 5 days ago. We seek to vary certain orders in the immediate because I'm pitted against two circumstances. One against Collins Moi, who's defying court orders, and one, my client who has 2 children who are not going to school. The 2 minors are not in school as we speak, and we need them in school immediately. Your Honor, these minors are beneficiaries to the estate of Jonathan Toroitich Moi. That estate has an obligation over them to maintain them and take care of them. I do pray that a variation of these orders be extended to summon the administrator of the estate of Jonathan Toroitich Moi to appear before court to explain why these children, minors, beneficiaries of the estate cannot be maintained and cannot be taken to school. Jonathan Toroitich Moi.
Just a minute. Yes.
Your Jonathan Toroitich Moi is a beneficiary of the estate of the late President Daniel Toroitich Moi by 20% portfolio. Those 2 estates, therefore, owe the minors in matter responsibility, and profoundly so, to take them to school, to support them in terms of the judgment, which has never been set aside, varied, or otherwise assailed on appeal. It is on this premise, therefore, and out of this urgency, that we request for mention date next week to have this information placed upon the estates. That even as we deal with the contempt law, premium is not lost on us, that there are minors who are suffering and need to be supported and be granted a chance to go to school, and the judgment in terms of prayer E and judgment in terms of prayer F and G be respected. My client has been paying their fee previously, but she has gotten to a point where she can no longer sustain it. In the alternative, if they are unable to, these children be taken to Geneva, where they were, for support by the government of Switzerland. And that would need facilitation to process their passports and take them to that country, because that's their country of birth. So those are the rafts of issues we are raising. We are also trying to trace Collins and or his lawyer They were here previously. They were aware of this gate. It's an evolving landscape, and we wish to have court orders respected in the absolute. We last communicated with my client on 10th of February this year. It cannot be said that it's not traceable, though it's gone under as we speak. So give us about 1 week to have him traced. If he's not traced, we, the alternate, swing in for the estate to take care of these minors. They cannot be at home where their peers and relatives are going to school. This is so prayed. I do want to be prayerful direction. Thank you.
Yes, just big one.
Yes, Your Honor, I'm present.
You must be familiar with the orders of the court that I issued on 21st of February.
No offer statement, kindly.
The orders I made on 21st of February 2024. Where I directed that this application be served upon the respondent in person. Was that done?
No, that was not done because of the absence and
Yes, my second order was that summons be extracted. Summons?
extracted.
Yes, summons requiring the respondent's personal attendance in court is served, for which show cause they should not be committed to civil jail for contempt of the orders of the court. Was that done?
We were unable to do that because of the absence and the disconnect between him and his lawyer, because the only source of tracing then was his lawyer. It does not stay in Kabarak and it does not stay in Nakuru at the moment. So we have to really go down on a hunt for him. He also changes his phone numbers and therefore even serving him through WhatsApp is an impossibility. I, however, endeavor to cause service upon him through whatever means we do.
The orders of the court were not even extracted for service.
Yes.
Yes.
But I have also tried to, it's a children matter, so I try to reach out to all counsel because these are not matters that are supposed to be very antagonistic at trying to be. They have the image of a 12-year-old and a 14-year-old to be taken care of. So we try to be as docile and as very diplomatic as we could.
Yes.
It is that stretch of events that I wish to now extract the same. I wish to have those orders extended, extract them forthwith, and trace Mr. Betman to be in court for purposes of further directions. I was cautious enough to earlier state that within a week we could do that.
Yes.
That's approximate time by Friday we should have served it. I didn't want to.
Here the orders of this court of 21st of February 20 extracted for action. I therefore direct that the orders of that date, as 21st of February 2024, be extracted for service upon the JD. The matter shall be mentioned for further directions on 13th of March 2024. The orders earlier issued are extended to that date.
Most likely. My name is Steve Biko Basur. I do represent my client, Jeruto, Gladys Tagi. Jeruto, Gladys Tagi, and Collins Kibet, Toroitich Moi have two minors, both parents to those minors. They've had a case in court relating to the maintenance and support of these minors. This matter ended up in court and a judgment was granted in favor of my client by Honorable Limo on 2nd of June 2022. It is pursuant to that judgment that we are now before court seeking to enforce the orders which were granted by that court towards maintenance of those children, and more particularly a concern pertaining their education, their food, shelter, as well as Medicare, which were apportioned to Collins Kibet Toroitich Moi. Unfortunately, we are at a point where the said Collins Moi has declined, or rather has neglected these minors to an extent that they are not in school as we speak. It is on this account that we came to court today to have him either put in civil jail for 6 months or to be ordered by the court otherwise to remit those sums which are outstanding for those children. We also note that these children were not born here in Kenya, they were born in Switzerland, and it is on this account that we were also requesting the court. In the alternative, they can't maintain the children here, they be taken back to Switzerland for purposes of maintenance. But even that cannot happen without the children being facilitated to go back there. We also state that these children are beneficiaries to the estate of Jonathan Toroitich Moi by a case filed in 2019, to be precise, Nairobi Succession Course number 705 of 2019, where Justice Muchelule ordered these minors to be made part of the estate. That's why we are saying belonging to that estate should not be cosmetic. It should be followed closely with legal obligations, and such obligations imposes upon the estate a duty to take care of those minors. They have not done that. So these children are basically being denied their rights of inheritance to the estate they belong to. We also note that Jonathan Toroitich Moi is entitled to the estate of the late President Moi by a 20% portion. By extension, these two minors are entitled to extract from either of the estates to support themselves to go to school. My client has done her part while she's having these children all through. The gentleman has never contributed anything and is not bothered. It is in the best interest of these minors that they go to school. Despite having a very powerful name to their surname, they cannot benefit from that. And they don't really want to benefit just because they have a bigger surname. They want to just be accorded what every other child entitled to a given legal order could be accorded. And that's why we then pursued those two or double-pronged approach to this issue. Instead of just going for Collins and putting him in custody, as we intend to do, what else after that? There are children to go to school, their mouths to be fed, there is housing, there's food, and there's care to be given to those minors. My client has single-handedly done that from birth. And the lifestyle these children had in Switzerland, Geneva to be precise, is not the same that they're having over here. They are left in a village in Ravine, and we don't think that is okay. The mother's done her best to even stretch herself maximally to the point she has done. Next forth is for the father to also have his input. Of course, he has had what we can call patched up communication with my client. Their relationship is also fairly broken down, but that does not concern the children. Whatever fights they could be having, the innocent parties whose interest we must further and further at all costs. That's why we have pursued it in court. So the judge, there was a previous counsel, my learned senior colleague, Mr. Mongeri. He did so well to even get this judgment, and we appreciate him so much. This last bit, we are informed that Collins no longer has a counsel, or rather his counsel is saying he's no longer representing him. So it is on that account that the court has directed that we serve him personally to avert the back and forth of whether the lawyer is present or is not present. We need to have Collins in court to take responsibility for what he's supposed to do to the minors. That's the background. So we come back on 13th of June to effect, one, the service, and number two, to take more directions from the court on the way forward. That's all.